Now, let's look at electronic document discovery, sometimes popularly referred to as e-document discovery. E-document discovery, also called e-discovery or electronic document discovery, refers to any auditable process in which electronic data is sought, located, secured, searched, filtered, and presented with the intent of using it as evidence in a civil or criminal proceeding. But let me quickly emphasize here that when we talk about e-document discovery, it is more suited to a discussion for use within civil litigation environment. Now, it is important to emphasize the point that it is not just a question of collecting electronic data. The process of collecting and filtering, searching the electronic data for evidential purposes must, of necessity, be defensible. The process must be auditable. The process must produce evidence that is authentic, reliable, and admissible. And most importantly, the process must account for the time factor relevant for the delivery of that information to the other party or to the court. Some of the terms that we are likely to confront, and loads of them under e-discovery, would be the shortened form of e-discovery. You occasionally hear, in fact very often hear, the term ESI being used to describe the e-discovery process. But ESI stands for electronically stored information. So in general, that's a generic term to describe electronic documents. So we'll be using that as we get along. Within the ESI environment, you will hear terminologies like data universe, data mapping, predictive coding. All of these are terminologies that will be floating around all over the place. But don't let that confuse you at all. The data universe will simply refer to the beginning of the process up to the end. Data mapping would refer to actually determining where the data is from, who produced it, and where it's going to. Predictive coding is actually employing computers to help with the search terms and search function of keywords or relevant words that will be useful for a particular case that you're dealing with. But before all of that, it is important to discuss two major concepts that underlie the discovery process: the ECA, early case assessment, and the EDA, early data assessment. You recall that I mentioned at the beginning of this slide that e-discovery is principally geared towards civil litigation. Just like you would formulate your case theory in criminal litigation, you are also required within the civil litigation end of things to determine what your case theory is and what your likely class of evidence would be to support your case. And of course, it would, I suppose, involve electronic documents or documents of some kind, but we are concerned here with the use of electronic documents and how to best use them to support your case theory. So it is important to conduct an early case assessment because it is based on what the ramifications of your case entails and what you have decided would be the relevant documents to be presented to support your case theory, or the species of documents requested by the other party. So it's not just a question of you assessing your case strategy. It must also include the requirements of the other parties I will refer to subsequently as the cast of characters. You must accommodate everyone's possibly everyone's interest with respect to what would the relevant documents be, because you don't want to concentrate on your own case theory or your own case position and ignore what is likely to be acceptable and rational request from your adversary, or even court-mandated orders for the production of certain documents. So your early case assessment must take all of that into consideration, and particularly moving from there to the EDA, early data assessment, because if you formulate a proper ECA, early case assessment, you should be able to reasonably, within the EDA framework, early data assessment, be able to first define what precisely is your data universe, your scope of data, who are the likely document custodians, who is actually responsible for producing this data. Your client might be a corporation, so you want to make sure your client understands that you will need these documents. And we'll be looking at some of the stages that completely addresses all of these early data assessment and going forward to see how the process progresses. But essentially, for an introductory lecture of this nature, what you need to understand is that from the word go, when it involves the possible use or the use of electronic documents, you've got to have in place, 1, an early case assessment, 2, an early data assessment. Now, let us move on to look at what the template for the preparation and production of electronic documents, ESI, would look like. And that's popularly referred to as the EDRM model, Electronic Discovery Reference Model. Now, what it primarily does is provides a template that helps to inform on what necessary steps you're required to adopt in the process of producing data. Let me quickly just go through here. You will find that first, there are about 6 major stages you're likely to go through. But again, like I said, this is a template. It's not like you must go through them literally, but there is, as we get along, I will show you by way of some demonstration how all of these processes can lead to some fruition. So let's see. On the information management stage here, as a lawyer, this is not likely to be where you would start, really. You are hoping that your client is proactive enough to have maintained some kind of information management structure within the organization if you're dealing with a company. And under this heading here, you're hoping, of course, that they have an IT department that has a document retention policies, can identify who are the custodians, for example, how are emails stored, where are they stored, are they easily accessible, what is the backup structure, backup policy, what is the document destruction policy, how long is all of that. You're hoping that all of this is in place. But unfortunately, in my experience shows that that is too much of an expectation on the part of the client. Usually you find that when you need these documents, they hardly can even tell you who would produce them. You need to know how easily they can be accessible, what is the burden involved in trying to get this document. If they are not in-house, are they with third parties? So all of this is the kind of information you would need to know beforehand. Unfortunately, that's an ideal world. You usually would confront all of these problems when you have the case at hand and you need information like yesterday. So first stage of information management, this is essentially something more, a stage that is more akin to be within the client's domain. But on the issue of identification, this is hoping, of course, that you have conducted a proper early case assessment, because in the absence of a well-coordinated early case assessment or identifying what your case really is, then it's difficult to really identify what specific documents you need and in what format you need them and who you should be asking this document from, because as far as the early case assessment is concerned, one of the requirements as a lawyer that you will be expected to have implemented is what we call a litigation hold. A litigation hold would be informing your clients or whoever is likely to be a party in the case to preserve documents that are likely to be used in the case. And it's a very serious requirement, because if that stage is ignored, then there's the danger of your client accidentally destroying relevant documents, and the court will view that very seriously, and sometimes it leads to very serious monetary sanctions, or even in some very serious cases, a complete dismissal of the case. So it is very important that on the issue of identification, you are assessing at this point who the litigation hold letters, preservation letters should be addressed to, and in fact, who are the likely document custodians that need to get this letter of litigation hold and the preservation letter. Then, of course, we're moving into the state of when this evidence is preserved. Then the next stage will be the collection. Now, you recall that one of the items I highlighted when we talked about what e-discovery is was the issue of it being an auditable process. So it's not just a question of collecting data. There has to be an auditable log that shows that this data was collected in such a way that it retained its authentic value. It's authentic. It's not been falsified, or its probative value has not been tainted. So essentially here, the bottom line is there must be some auditable forensic log to indicate how this data was collected for processing. Now, the processing of the data would largely involve, given the volume of data that is usually produced by computers, would detect an attempt to reduce the volume of data. If you look at the the graphics we have here, you find that this yellow bit of it here, as the process moves forward, the volume of data actually reduces. That should be the ideal way to perform an electronic discovery process for ESI documents. And as the volume of data reduces, you will see that the level of relevance of the documents collected would increase. So the processing actually would involve conducting proper search of the document universe, and that will depend on the use of appropriate keywords. But here again, some note of caution. The keywords in question are not ideally keywords that are convenient for your case. Take note that the keyword might be one that the court has mandated to be agreed between the parties in order to reduce cost and expense and save time. So these are matters before you get to this stage that ought to have been taken care of at a pre-trial case management meeting. In the United States, they refer to it as a meet and confer. So it is at all of that point that the keywords is likely to be agreed by both parties. And you recall we talked about predictive coding, and for time saving again, the courts may allow parties to agree on the best way to conduct the processing. And it is at this stage also that parties should be careful about privileged documents and work product documents. So at the stage of processing, all of this is important. And one other important issue I must quickly mention here is that it is not just a question of processing and producing documents. It's a question of processing and producing documents to an agreed format and schedule. I'll repeat that, agreed format and schedule. Because sometimes the other party would require the document to be produced in its native form if they are emails, or to be produced in image format. There has to be an agreement to that extent. There's no point spending all the client's financial resources producing documents that will not be acceptable to the other side. So always make sure there's this prior agreement on format of production, the scheduling of production, that's the time frame involved, and of course an understanding on the accidental release or use of privileged documents, and an agreement on what the acceptable keywords would be for the particular case. And so you do all of that at the review stage, hoping of course that you've gotten an agreement on that. And if you do not get that prior agreement, it is always necessary to bring that to the attention of the court before you begin your processing, because otherwise you might just end up repeating the entire process. Okay, so in terms of review, processing, review, and analysis, these are some of the issues that you need to take into consideration. Then, as far as production is concerned, I did mention that it was necessary to have a prior agreement with the other side as to what format and what medium the delivery of the extracted ESI would be in. So if there's some agreement that some of these identified ESI should be in their native formats, maybe emails, and some of the other documents could be in PDFs, then that agreement has to be complied with, and make sure all of this is documented. And what medium would it be? Do they want the extracted images in a CD-ROM, DVD, indexed or hosted by a third party on an accessible website? What format do they want it in? Do they want it in such a format, a CSV, an Excel file, an indexed file? Do they want them bit stamped? There has to be agreement on all of these prior to production. Again, it is important to have that agreement. Where the other parties is becoming pretty difficult, then the court needs to be aware and request for the court's further directions on this issue. Then, of course, on presentation, you want to determine what's your best form of presenting this data. At this point, really, it's got much to do with how convenient it is for you and how suited is the court for the presentation of your materials. There are a lot of professional presentation materials out there, trial director, exhibit view, that you could use in presenting your ESI materials. So, in summary, we've just gone through the EDROM model for electronic document discovery. Now, what are some of the anticipated difficulties involved with the use of electronic documents? Of course, number one among them will be the client. Your client may pose some difficulties because, one, you recall that we mentioned, looking at the EDRM model, about the information management. Information management should have proactively occurred. If your client is a corporation, should have proactively occurred within the company of your client. So ideally, as the lawyer, you would have expected to do was to identify what evidence you need and who are the document custodians, and send the proper preservation letter and litigation hold to these individuals. But that's an ideal world. It usually doesn't work that way. You only find out the late hour that your clients cannot even find the emails that you're referring to. Suddenly the backups tapes are not available, or it's going to take 1 million years to get them converted, or they have deleted files that were relevant, or someone did not get the litigation hold later. All sorts of things can happen. So it is better to always proactively deal with your client once there is the prospect of litigation that concerns certain document custodians. Now, the second bit of the challenge will be what to collect. Again, you recall that I mentioned that one of the things you need to do would be to conduct an early case assessment, an ECA, because if you conduct a probative and productive ECA session, then you should know what to collect. But I must quickly add here that what to collect does not simply depend on what your case theory is. It will also depend on what the demands of the other party is and what the court has also requested. Now, the third challenge will be the time and required expertise. The ECI process it's relatively complicated if not properly managed, and very often time is of the essence. So you will find that you're dealing with a very tight time schedule, and you would require the relevant expertise to deal with that. Experience has also shown that lawyers or parties usually would use the discovery of ESI as a tactical strategy, either to slow down proceedings or to gain undue advantage. And so in that regards, instead of asking for a particular email that is relevant to a fact and issue, there will be a document request for 3 or 10 years email way back for production. And given the time, expense, and expertise required for this, it is always important that you measure the proportionality of the request from the other side with the case at hand. And if that is going to cause some prejudice to the case of your client, that must immediately be brought to the attention of the court to vary and make further directions as to proportionality before the production process begins. The issue of accessibility is also useful here in trying to defend unreasonable requests for the production of electronic documents. Because if, for example, the document required or requested by the other party is not easily accessible, or there is the presence of duplicates of these documents, then it does not make sense to demand it from your client. A good example would be emails. If an email has been copied from the adversary to your client, the other party cannot, in the absence of not locating a copy of their own email, insist on you producing that email. If they have a copy, then there's an alternative source of finding that document, and they should take advantage of it. So in terms of abuse of the ESI production process, the question of proportionality, accessibility, and prejudice and cost should be taken into consideration when you're trying to defend an undue request for the production of ESI. Now, the other challenge that can come to the fore is the determination of the search criteria. How do you agree on search keywords? How do you determine which keyword is relevant? Again, I go back to the importance of conducting a proper early case assessment. If you conduct an early case assessment that is relevant to the case theory that you're putting forward, then of course you should be able at that point in time determine what your likely keyword search would be. And most of these search criteria would be supplied by the proprietary software technologies that will be used in conducting ESI. What is important is that you agree on these search words prior to the production process itself. Of course, we've talked about the volume management of documents, because again, like earlier indicated, with ESI, as you go deep in the process, the volume of documents should reduce, and the volume of relevance of the documents you now have should increase. It should not be the other way, because don't forget, you're trying to cut down costs also in terms of how much documents you produce. Of course, you have to take advantage of the fact that you should not accidentally produce privileged documents, and that simply means you must undertake a proper review process at this stage when you're conducting your review of your documents. The review and analysis will be very crucial at this point. So even if you have external lawyers who are involved in the review process, they must understand what they're doing and what is likely to be privileged documents. Again, you could help yourself in doing this by incorporating privileged documents and excluding them in the search criteria. And even where the documents are this confusion or disagreement as to whether or not they're privileged, then you should take advantage of redacting some portions of the document that may amount to passing on privileged information. Then, of course, the other challenge, collecting evidence from social networking sites like Facebook and Twitter, because most of these platforms are based on cloud computing. Most of the substantial evidence will be found on the servers of the social website owners like Facebook and Twitter. But that's not to say we cannot find artifacts of these social websites like Facebook and Twitter on client computers. That's also a challenge, but that can be found. One other issue that comes to mind again in terms of anticipated difficulties with ESI is the possibility that your discovery needs for ESI may actually go beyond national boundaries. So which simply means, of course, that you will be confronted with resolving issues of conflict of laws, data protection laws, human rights laws, just to get your ESI to present. So for lawyers who have clients in foreign jurisdiction, it is always important to make sure you have a feel of what the requirements in terms of legislation and data protection would be for the use of foreign documents in assessing and transferring foreign documents. Then, of course, ultimately, if all of these is not properly handled, all of these stages are not properly handled, you're likely to have sanctions applied, and they could be very heavy sanctions indeed. And so these are some of the issues. And in terms of how to resolve all of these and not get into the realms of being sanctioned, we would look at some solutions and, of course, the consequences we've talked about. So in terms of solutions, first, there must be a conscious attempt to implement litigation readiness. Again, in an ideal world, the litigation readiness plan, which understandably should be a proactive plan, ought to have been implemented at the client end, but that is not always the case. So invariably, as a lawyer, what you can do is to make sure you act timeously when there's the potential for litigation. You don't have to wait to get pleadings from the other end or get a court order before you start contacting your client to ensure the preservation of documents and readiness for the production of ESI. So litigation readiness is important. Then, of course, the issuance of the litigation hold notices and preservation notices is very crucial because if the lawyer does not inform the client of the legal need for a litigation hold and preservation of evidence, that could amount to professional negligence for which it can be sued and sanctioned. So it's important to make sure the litigation and preservation notices go out to the appropriate document custodians to preserve evidence. It is also important going forward to conduct interviews with your clients and all relevant parties and reinforce the need for ESI preservation and to ensure that they understand the need to preserve evidence. And of course, collection is pretty important because at the collection stage, you want to ensure that the process of collection is an auditable and forensic one that is repeatable. So you don't want to end up getting involved in the collection process that is contested and that is very likely to have tainted or made less probative the electronic evidence. But even more important is what I refer to as the cooperation process. You can get all of these other processes ready effectively, but if you don't have the cooperation of the other side and the court, then all of this effort is wasted. So what I would suggest very strongly is that with reference to the use of electronically stored information, there must be cooperation between both parties. And in fact, in some jurisdictions, particularly in the United States, and in the UK, of course. Most of these in the US, that's been coded, but in the UK, that's by way of practice direction. Parties must cooperate in the production of ESI, because that's the only way cost can be taken care of, and the timeframes can be adhered to. There should be no conscious attempt, as it were, to use the production of ESI as an oppressive strategy. You would recall that if that happens, then you can, by way of applying to the court to vary the scope of discovery, depend on issues of proportionality, accessibility, prejudice, and burden of production. You can use all of these grounds in your application to appeal to the court to vary the scope of ESI. But then again, you cannot properly rely on these grounds if you have not conducted a meaningful ECA, early case assessment, and early data assessment program. So it is important that you undergo most of those properly, the ECA and EDA program, before the cooperation stage. So at that point, you can have or make cogent arguments or proposals based on facts that you already have, not just based on assumptions, because the other side would come prepared also. So it is always good to make sure you get all of these ready and understand where and what problems you are likely to confront, given the level of scope of discovery that may be proposed by the other side. And in terms of consequences, like I said, you don't want to go there at all, because sanctions could range from hefty financial penalties to dismissal of plaintiff cases or defendant case, and sanctions and penalties on the lawyers. We've even had cases where clients have sued their lawyers for professional negligence because they were not adequately advised on the preservation of ESI.